Dear students, Namaskar. In my last lecture, again, which was related to the important chapter of amendment, and we were concluding the landmark and historical case, Keshwanand Bharti. Although in my previous lecture I completed the Rajnayan also, but what I came to found later on when I switched off my lecture that it was not fully recorded, and it was uh, concluded to the last conclusion or the conclusion of Keshwanand Bharti, which was quoted by the two important judges of the Supreme Court. As all of you know, that I am again connecting myself to my previous lecture, that all of you know in Keshwanand Bharti, in which was in which the Keshwanand Bharti illustrated judicial creativity and the policy making role of Supreme Court of a very high order. The majority judges sought to protect and preserve the basic and fundamental parts of constitution against the onslaught of parliament or against the onslaught of the transient parliament or transient majority of parliament. The basic philosophy underlying the doctrine of non amendability of the basic features of the constitution evolved by Keshwanand Bharati by the majority. It has been beautifully explained, or it has been beautifully explained in Keshwanand Bharati by Justice Hegde and Justice Mukherjee as follows: that our constitution is not a mere political document. It is essentially a social philosophy, like a social document. It is based on social philosophy, and every social philosophy, like every religion, and every religion which has two main features, namely basic features and circumstantial feature. The former remains constant, means the basic feature remains constant, but the later is subject to change. So, likewise, a constitution like ours contains a certain basic features, fundamental features, which are to be termed as essential features, and that they cannot be changed or cannot be destroyed by applying the amending power by the parliament. So it's the Justice Hegde and Mukherjee which beautifully illustrated the importance of fundamental and basic features of any concept or of any uh, document, that basic features and fundamental features are unamendable and are eternal, and that's why are to be considered, are to be termed as basic structure of the constitution. In retrospect, it would appear that Supreme Court adopted the techniques of literal interpretation of constitution in Sankri Prasad and Sajan Singh, and thus concluded that there was no restriction on the amending power. Things, however, changed when Chief Justice Subbarao, a great protagonist of the fundamental rights, took over the leadership, of the court and had an opportunity to preside over the bench, deciding the Golaknath case. It needs to be emphasized that decision of the question whether the amending power should be restricted or not involved a high policy making function on the part of the judiciary. So it was not a question which could be decided merely by resorting to logical arguments, as arguments could be found on both sides of the line. So in course of time, the doctrine of fundamental and basic features of constitution has become very well entrenched in India. Since Keshavananda Bharati, the doctrine has been applied by the Supreme Court in quite a few cases. Keshavananda, Keshavananda constitutes the high water mark of judicial creativity. So it was all about the landmark judgment Keshavananda Bharati, in which the Supreme Court ultimately held that although the Parliament had power to amend the every provision of the Constitution, provided basic structure of the Constitution, and the what does it mean that the Parliament had limited powers, not unlimited or absolute power for amending the constitution or for exercising the constituent amending power by the parliament. As all of you know, that this case was decided by the Supreme Court on 24th April 1973. In the due course of time, what happens that in next case in which the Supreme Court had the opportunity to apply the doctrine of basic structure, which was propounded in Keshavananda Bharati, and that ruling, as all of you know, regarding the non-amendability of basic structure or basic features of the Constitution. Actually, what happens in 1975, the election petition filed against Srimati Indira Gandhi in Allahabad High Court, it was decided against her, and her election was declared null and void because of the provisions or norms of People's Representative Act were totally flouted in her election, so it was declared unfair election. Then she filed an appeal in Supreme Court, but the Supreme Court did not give absolute stay, and such judicial independence was not to liking of Mrs. Indira Gandhi or Srimati Gandhi, and that's why she apprehended that she would be unseated from his office and disqualified by the Supreme Court. She had requisite majority in both houses of the parliament and state legislatures, and also comfortably uh, she was able to have the ratification from the more than half of the states in India, and that's why she had decided to change the election laws and the constitution to protect her office. Here it's uh, more interesting, more interesting that that more interesting that the 11th of August 1975 the appeal was fixed. The next hearing of appeal was fixed by the Supreme Court or before the Supreme Court. Between 7th August, because the date was fixed for 11th August of 1975, between 7th August and 10th August, the 39th constitutional amendment was passed by both houses of the parliament and ratified by requisite number of state legislatures and assented by the president. The bill was introduced on introduced in Lok Sabha on 7th August 1975 and passed it on the same day. Rajya Sabha passed in uh, 8th of August 1975, and several and you know that it's the several statutes ratified, or sorry, several states ratified it on 9th of August 1975, and on the 10th of August 1975 the president assented to it, and it was published in Gazette as a 39th constitutional amendment to put her election of Lok Sabha beyond challenge. And the new Article 329A was inserted, and clause 4 and 5 of the article declared as below. They were inserted, they were attached to Article 329A. Clause 4 says that such election shall not be deemed to be void or ever to have become void on any ground, and notwithstanding any order made by any court declaring such election to be void, such election shall continue to be valid, and such order shall be deemed to have been void. So you could see that in this very intelligently manner, clause 4 was inserted in the uh, election, sorry, in the article article 329A, so that the election could not be declared unconstitutional by the Supreme Court, and the decision could not could not be have its own impact on the office of the uh, Prime Minister. Clause 5. Clause 5, uh, any appeal or cross appeal, any such order of any court is referred in clause 4, pending immediately before commencement of 39th constitutional amendment before Supreme Court shall be disposed of in conformity. Again, both clause clause 4 and clause 5, they were interlinked. And that's why this clause 4 and 5 of article 329A was challenged before the Supreme Court, and here the Supreme Court applied the doctrine of basic structure of the Constitution, which was evolved in Keshwananda Bharati, and the majority held that to be held clause 4 to be invalid and struck down on the ground that it was beyond the amending power of the Parliament, as it destroyed the basic structure of the Constitution. And here it was Justice H.R. Khanna. As all of you know, uh, Justice H.R. Khanna had also played a pivotal role in the case of Keshwanand Bharati, because he had tilted the balance tilted the balance and making the majority opinion, or supported the majority opinion. Here also, Justice H.R. Khanna struck down the clause on the ground that it violated the free and fair election, which was an essential postulate of democracy, and which, that all of you know, that democracy has been declared as the basic structure in Keshwananda Bharati case. So, and being essential feature, free and fair election is the being essential element of democracy. So that's why the election was, or the clause 4 was declared unconstitutional. Justice Chandrachud struck down clause 4 and 5 as unconstitutional on the ground that they were outright negation of the right of equality conferred by Article 14 of the Constitution, and a right which is basic postulate of our Constitution. He held that these provisions were arbitrary and calculated to damage or destroy the basic structure of the Constitution, and also destroy the rule of law. So, the Supreme Court has now, or thus, added a new following features to the list of basic structures, which was evolved in Keshwananda Bharati case. Now the Supreme Court added another features, like that rule of law is also the basic structure of the Constitution. Judicial review, because you know that it was the judicial review is the basic structure of the Constitution. Why the Supreme Court propounded that judicial review is the basic structure of the Constitution? Because it was clause 4 and 5 of Article 329A was depriving the courts from its power of judicial review. Then democracy, which implies the free and fair election, is also the basic structure of the constitution. And here, one thing was also held by the Supreme Court. The Supreme Court also held that legislature means that either it is the central legislature or the state legislature had no power to decide the controversies between the private parties, because because all of you know that the dispute related to the election of Mrs. Gandhi was a dispute between Mr. Rajnarayan and Mrs. or Srimati Gandhi. So it was not supposed and it was not expected to be decided by the parliament. So it was unfair, and that's why the clause 4 and 5 was to be declared invalid and unconstitutional in this landmark decision. And here it was the first case in which the Supreme Court had applied the doctrine of basic structure of the constitution. Now, uh, those claiming unlimited powers was who were claiming the unlimited power. It was the parliament. So those claiming unlimited powers of parliament or parliamentarians felt aggrieved by the decision in Indira Nehru Gandhi versus Rajnayan. And parliament this time brought a 42nd constitutional amendment, which was a revision of constitution. And that is why, all of you know, that is why the 42nd amendment is to be termed as a mini constitution, because it was very bulky uh, amendment, and that's why that is to be termed as a mini constitution. Article 368 was amended, and two clauses 4 and 5 were inserted to Article 368. Now, clause 4 declared that no constitutional amendment, whether made before 3rd January 1977 or after it. Why this date was fixed? Because it was the date on which constitutional amendment, means that 42nd constitutional amendment was enforced. So that's why uh, whether made before 3rd January 1977 or after it shall be called in question, means that no constitutional amendment shall be called in question in any court on any ground. And clause 5 stated that there are no limitation whatever on the constitutional amending powers of the parliament to amend the constitution. So the obvious purpose of the constitutional amendment to Article 368 was to take away the grounds on which Keshwanand Bharati and Indira Nehru Gandhi case stood. So the parliament may maul or modify the constitution at its places. So there would be no shackles on the power. Even if it does not follow the prescribed procedure, no objection can be taken. So that's why the 24th constitutional amendment had already provided that it was obligatory for president to assent the bill. So thus in tug war between the parliament and the Supreme Court, the parliament donned a protective armor and waited. And now, as it was expected, because as we termed that it was a tug war between the parliament and the Supreme Court, then again this the scope and extent of the doctrine of basic structure was again considered by the Supreme Court in the case of Minerva Mills versus Union of India of 1980. Here, the court again reiterated the doctrine that under Article 368, Parliament cannot so amend the Constitution as to damage or destroy the basic structure or fundamental and basic structure or essential features of the Constitution. And in this case, the petitions were filed in the Supreme Court challenging the taking over of the management of a mill under the Sikh Textile Undertaking Nationalization Act 1974, and an order was made under Section 18A of Industrial Development and Regulation Act of 1951. So the petitioner challenged the constitutional validity of clause 4 and 5 of Article 368 introduced by Section 55 of 42nd Constitutional Amendment Act. If these clauses were held valid, then the petitioner could not challenge the validity of 39th Constitutional Amendment Act, which had placed the Nationalization Act 1974 in ninth schedule. So, as Section 55 of 42nd Constitutional Amendment Act inserted clause 4 and 5 in Article 368. So, in this case, the section was held to be beyond the amending power of Parliament and declared void, since it sought to remove on the power all limitation on the power of Parliament uh, to to amend the Constitution and confer power on Parliament to amend Constitution so as to destroy the fundamental, basic, and essential features of the Constitution or its basic structure. So, the newly introduced clause 4 and 5 in Article 368 inserted to deprive the courts of their power to call in question any constitutional amendment. The Supreme Court stated in this connection that our Constitution is founded founded on a nice balance of power among the three wings of the state, namely legislature, executive, and judiciary. And it is the function of judges perform their duty to pronounce upon the validity of laws. Depriving the courts of the power of judicial review will mean making fundamental rights a mere ornamental or mere adornment. So, as they will be rights without remedies, and a controlled constitution will become uncontrolled constitution. So, the newly added clause 5 of Article 368 sought to demolish the very pillar on which the preamble rests by empowering the parliament to exercise constituent power without any limitation whatever. The clause even empowered the parliament to repeal the provisions of constitution. So the parliament thus abrogate the democracy, substitute for it uh, an unethical form of government, and they can most effectively be achieved without uh, calling the name by a total denial of social, economic, and political justice. And uh, social, political, and economic justice to the people by emasculating liberty of thoughts, expression, belief, faith, and worship, and by abjuring a commitment to the magnificent ideal of a society of equals. So, a limited amending power is indeed one of the basic and fundamental of the Constitution. Therefore, the limitation on the power cannot be destroyed, or in other words, the Parliament cannot, under Article 368, expend its amending power so as to acquire for itself the right to repeal or abrogate the Constitution, or to destroy the basic structure and essential features of Constitution. Here, Section 4 of 42nd Constitutional Amendment uh, amended Article 31C, which all of you know that 31C was inserted by 25th Constitutional Amendment in Constitution, and uh, it the its first part and it was challenged in Keshwananda Bharati, and all of you know that its first part upheld in Keshwananda Bharati, and which had given primacy to the laws related to Article 39B and C over the fundamental rights uh, under Article 14 and 19. But now the new amended Article 31C vastly expanded and now made the provision that laws related related to all directive principles will be having primacy over the fundamental rights under Article 14 and 19. So, this newly amended Article 31C challenged in this case means that challenged in Minerva Mill case, and Supreme Court now declared declared to be invalid as being beyond the amending power of the Parliament, since it destroyed the uh, basic and essential features of the Constitution. So the majority in regard to the 31C, uh, the majority judges insisted that fundamental rights occupy a unique place in the lives of civilized society, and the they constitute an arc of the Constitution. The Indian Constitution is founded on the bedrock of the balance between part third and part fourth to give absolute primacy to one over the other is disturb the harmony of the Constitution, and this harmony and balance between the fundamental rights and directive principles is an essential features of the basic structure of the Constitution. So here in this Supreme Court held that the balance between the balance between the fundamental rights and directive principle is the basic structure of the Constitution, and it's the function of the government that they must maintain the balance or conflicting balance between the fundamental rights and directive principle. Means that the blanket protection should not be given to one at the cost of other. So the Constitution the Supreme Court pointed out pointed out the goals set out in Part Fourth, that is directive principle must be achieved without the abrogation of the means provided for by Part Third of the Constitution. That is, the fundamental rights uh, sense. In this sense, fundamental rights and directive principle both together constitute the core of the Constitution and combine to form its conscience. So anything that destroys the core of the Constitution means that balance of the uh, between the two means the balance between the fundamental rights and directive principles. Then it will be the murder murder of conscience of the Constitution, because the balance of the both combine of the both makes the conscience, and that's why the Supreme Court indicated that anything that destroys the balance between the two parts will ipso facto destroys a essential element of basic structure of the Constitution. And the Supreme Court also indicated that if Article 14 and 19 were put out of the operation in regard to bulk of legislations, then Article 32 would drain of much of its lifeblood. Because all of you know that as and when there is a violation of Article 14 and 19, then people always run, always rush to the Supreme Court for filing writ petition under Article 32, or rush to the uh, High Courts under Article 226 of the Constitution. And in case if the both articles are going to be made lifeless or defunct, then obviously the purpose of Article 32 will also be defeated, or the blood of Article 32 will be dried from its body. So that's why uh, that's why the nature and quality of constitutional amendment were such that virtually uh, tears away the heart of basic and fundamental freedoms, because in case if Article 19 is going to be taken away, then what will happen? It will the virtually uh, it will be the virtually the tears away the heart of the uh, fundamental and basic freedoms. The state legislature were given an almost unfettered discretion to deprive the people of their civil liberties. Means that in case uh, if the all directive principles are going to be given primacy or the right under Article 14 and 19, then it will be deprivation of the fundamental basic liberties in any in the civil societies. Um, so here it was again, all of you know that I have got referred, I have got appreciated a lot for Justice Bhagwati and Justice uh, Krishna Iyer. So here, Justice Bhagwati, although expressed, although expressed minority view, but he was agreed with the majority in holding amendments to Article 368 as invalid and unconstitutional. On the ground of damaging the basic structure of the Constitution, he held that the two clauses 4 and 5 were interlinked, and he failed to appreciate how Parliament, which has only a limited constituent power, which had only a limited power, constituent power of amendment, and which cannot alter the basic structure of the Constitution as laid down in Keshavanand Bharati case, can expand the power of amendment so as to confer upon itself the power to repeal or to abrogate the Constitution, or damage or destroy its basic structure, or to convert it into an absolute and unlimited power, convert itself uh, into an absolute and unlimited power. So here, although the Justice Bhagwati uh, gave a minority decision, or gave a minority decision, but he spotted the view that clause 4 and 5 of Article 368 were invalid and unconstitutional. And here, Justice Bhagwati also commented adversely on the attempt to exclude the judicial review of constitutional amendment. But uh, as um, but as per him, means Justice Bhagwati, constitutional amendment to Article 31C was held valid, subject to gloss put by him. He argued that where protection was claimed for statutes under amended Article 31C, the Constitution, the court would first determine whether there is a real and substantial connection between the law and a directive principle, and that the prominent object of law is to give effect to such directive principle. If the answer to this question, if the answer to this question turns out to be yes, means that in case if there is a real and substantial connection between the object of the law related to the directive principle, then the court would then consider which provision of the law are basically and essentially necessary for enforcing the directive principle, and only such provision would be protected under Article 31C. All of you know that by 42nd Amendment, uh, the 31C was also amended, and as we discussed that it's the all directive principles were given or the laws related to all directive principles were given primacy over the fundamental rights under Article 14 and 19. So, uh, the Justice Bhagwati declared this law by or declared this amended 31C uh, constitutional, provided or subject to this uh, condition, that in case if there is a real and substantial connection between the law enacted in relation to the directive principles and and if it is to be found to serve the purpose or objective, then it can be protected under Article 31C. And but if the courts find that a particular provision is subsidiary or incidental or not eventually and integrally connected with the implementation of directive principle, or it is of such nature that though seemingly a part of general design of the main provision of the statutes, and its dominant objective is to achieve an unauthorized purpose, then it would not be protected under Article 31C. So, in this formulation, the court would have discharged a much more overt policy making role, which the courts do not usually release. So here uh, the following observations could be cited as worth taking note. The following observation made by Justice Bhagwati could be taken as worth taking note. What's the observation? How it was observed, and what observation was made by Justice Bhagwati? That it is possible that in a given case, even an abridgment of a fundamental rights may involve. It is always a possibility. It is always possibility that in given case, even an abridgment of fundamental rights may involve a violation of basic structure. There are possibilities that in case if there is a violation of fundamental rights, then violation of basic structure also. It would all depend on the nature of fundamental rights, the extent and depth of infringement, the extent and depth of the violation of fundamental rights, and the purpose for which the infringement is made, and the impact on the basic values of the constitution. Means that as and when we are going to take an account of infringement or violation of fundamental rights, we will have to take an account of uh, all these tests, to whether up to the what extent and in depth of infringement, and the purpose of which the infringement is made, and the impact of basic values of the constitution. And he asked, they take an example of Article 21, which guarantees for right to life and personal liberty. So uh, this stands on an altogether different footing from other fundamental rights. How Article 21 stands on different footing as compared to other fundamental rights, as all of you know, Article 21 is more important, which talks about the right to life and personal liberty as compared the fundamental rights guaranteed under other articles of the Constitution. So that's why uh, it is a totally different footing from the fundamental rights. And here he quoted that I do not wish to express my definite opinion, but I may point out that if this fundamental rights is violated by any legislation, it may be difficult to it may be difficult to sustain a constitutional amendment which seeks to protect such legislation against the challenge under Article 21 of the Constitution. So here, you know that he advocated advocated for the for the validity and constitutionality, as per his opinion, constitutionality, his views that 30 even amended Article 31C was valid and constitutional by putting or by giving his forceful argument and forceful, opinion in these parts. So now coming to another important case law which relates to the basic structure, which relates to the amendment of Constitution, and that case uh, relates to your 31A, 31B, and even 31C. Here, in this instant case, this case was the Vaman Rao versus Union of India. It was the case of 1981. In this instant case, the Supreme Court considered the validity of Maharashtra Agriculture Land Ceiling on Holding Act, Ceiling and Holding Act, 1961. The act impugned ceiling on agriculture holding in the states, as the act had been placed in 9th schedule. The constitutional validity of Article 31A and 31B and unamended Article 31C, you know that unamended means as it existed before 42nd constitutional amendment. Sorry, as it existed before 42nd constitutional amendment. So now in this case, what was challenged? The constitutional validity of 31A, 31B and unamended Article 31C was also challenged on the ground of damaging the basic structure of the Constitution. As all of you know, that first constitutional amendment introduced 31A into the Constitution with retrospective effect, as well as 31B. As we discussed earlier also, that even in case if any legislation in any act had been declared unconstitutional by the court, and if it was later on if it was added to the ninth schedule, then it had become immunized from the judicial scrutiny or from the judicial review. So the its first constitutional amendment has given birth to Article 31A and 31B, and the fourth constitutional amendment amended the first constitutional amendment. As we have got discussed again, I would like to recall one landmark judgment or pronouncement delivered by the Supreme Court in Bela Banerjee case, in which case the Supreme Court held that the question of adequacy of compensation is justiciable. Means that the compensation, the issue of the adequacy of compensation or is justiciable, and because of that decision, the Parliament had to introduce fourth constitutional amendment, which had amended the first constitutional amendment and inserted Article 31A clause 1, which had obliterated Article 14, 19 and 31 of the Constitution totally and completely for the laws within its scope. Means that the so in this connection, uh, we can say that this case was filed. The Supreme Court, Mahavir Rao, was filed, and here the Supreme Court has ruled by majority that all amendments to the Constitution made before 24th April 1973, as all of you know that this date was the date of the decision of Keshwanand Bharati case. What Supreme Court ruled? The Supreme Court has ruled by majority that all amendments to the Constitution or constitutional amendments made before 24th April 1973 and by added and by the ninth schedule was amended time to time by inclusion of various acts and regulations, they were valid. Means that the constitutional amendments which were added to ninth schedule before 24th April 1973, the Supreme Court ruled in this case that all those were valid and valid and constitutional. But the amendments made on means that the amendments made on 24th April 1973 or after 24th April 1973, which amended the ninth schedule and including various acts and regulation therein. means in ninth schedule, were open to challenge on the ground that they or any or more, they or any or more of them are beyond the constituent amending power of the parliament, since they damage the basic structure and essential features of constitution, or they destroyed the basic structure of the constitution. So the constitution in the Supreme Court in Vaman Rao case has not pronounced upon the validity of the such subsequent constitutional amendments, except to say that any act or regulation included in ninth schedule, except included in ninth schedule by constitutional amendment after 24th April, or before 24th April, is saved by Article 31A or by Article 31C, as it stood prior to 42nd Constitutional Amendment. The challenge to the relevant constitutional amendment by which that article, that acts and regulations to put in ninth schedule on the ground that constitutional amendments damages or destroys the basic structure of the constitution. Chief Justice of India, the then Chief Justice of India Chandrachud, said that his judgment in Vaman Rao that acts and rules included in ninth schedule before 24th April 1973 could not be challenged on the ground of being inconsistent with fundamental rights or two fundamental rights. But the acts or regulations included in ninth schedule after 24th April 1973 would not be protected by Article 31B, for the simple reason that because of the reason, because of the decision, Keshavananda Bharati case, that these would that there would not be no justification for making addition of acts or regulation to the ninth schedule to confer a blanket protection. Blanket protection. He further observed the various constitutional amendments by which addition were made to ninth schedule on or after 24th April 1973 will be valid only if they don't destroy the basic structure of the constitution. So according to Justice Bhagwati, all constitutional amendments, made after the decision in Keshavananda Bharati case would have to be treated by reference to the basic structures doctrine, Bhagavati added further that in every case where a constitutional amendment includes acts and regulations in ninth schedule, its constitutional validity would have to be considered by declared invalid to the extent to which it damages or destroys the basic structure of constitution by according protection against violation of particular fundamental rights. Means that in case if there had been a violation of fundamental rights and that violation of fundamental rights amounted to damage or destroy the basic structure, then that would not be permissible and that was to be declared null and void. So the above judicial observations in Vaman Rao reflect some inconsistencies. For example, first, whether an act which or part of which is has been found by Supreme Court to violative of fundamental rights under any article of 14, 19 and 31 can be included in ninth schedule, or whether it is only a constitutional amending the ninth schedule and that damages or destroy the basic structure of the constitution that can be struck down. So these two questions were raised, and in case of I.R. Kohilo, first time, which was filed in 2005, in case of I.R. Kohilo, a constitutional bench of Supreme Court consisting of 5 judges have referred the matter for decision to a larger bench of 9 judges, and the propriety of provision like Article 31B read with 9th schedule is highly questionable. So no act, highly questionable, no act mentioned in 9th schedule can be invalidated on the ground of violation of ground of its with the fundamental rights. Means that no act mentioned in ninth schedule can be invalidated on the ground of violation of fundamental rights. A blanket protection, second question, the blanket protection given to the statutes mentioned in ninth schedule. However, violation of fundamental rights it may be, even when an act is declared unconstitutional. So it is revived as soon as it is included in the ninth schedule, because a blanket protection is to be given to the statutes mentioned in ninth schedule. However, it was violating the fundamental rights. In case if it has been declared unconstitutional by the courts, it was revived and now it is revived as soon as it is included in the ninth schedule. Thus, uh, the judicial review. Thus, the judicial review on the ground of fundamental rights is completely excluded as soon as an act is put in the night stool. That as an although it was declared unconstitutional, but as soon as it was put in the night stool, then the judicial review was totally excluded. The power of judicial review was totally deprived. The schedule has not present more than the schedule uh, presently. The schedule has at least more than 284 statutes added therein, which have been totally immunized from the effect of fundamental rights. Thus, the Supreme Court has asserted time and again, that judicial review constitutes the basic structure of constitution. So one serious question arises: how are Article 31B and the ninth schedule, which excludes hundreds of all and sundry acts from the scope of judicial review, means that once time and again Supreme Court uh, declared that judicial review is the basic structure. Then again one serious question arises, that how Article 31B and ninth schedule, which excludes the hundreds of laws, hundreds of hundreds and more, and sundry acts from the scope of judicial review on the ground of breach of fundamental rights, especially fundamental rights under Article 14 of the Constitution, which confers the right to equality and which makes the provision of rule of law, which has also been declared basic structure of the Constitution. Here, in case if you are able to recall, the judgment of Srimati Indira Gandhi and Raj Narayan, in that case, the Supreme Court added another three important features as the features of as a basic structure of the Constitution. It was the uh, rule of law and judicial review. So it raised the serious questions that right to equality is a rule of law, which has also been declared as basic structure and basic structure of the Constitution are constitutionally valid. So all said and done, it seems necessary to reconsider the question of the validity of Article 31B in Ayer Coelho. All said and done, it seems necessary to reconsider the question of the validity of Article 31B, especially after Supreme Court decision in L. Chandrakumar versus Union of India 1997, in which case, the decision of Sampat Kumar was overruled, and here Supreme Court has unequivocally asserted in the relation to Article 323B by the virtue of Article 323B, tribunals were put at par of high courts, and that's why the Supreme Court has unambiguously or unequivocally asserted in relation to Article 323 and held that the power of judicial review over legislative action vested in high courts under Article 226 and Supreme Courts under Article 32 is an integral and essential feature of Constitution. And that is why in this case the Supreme Court held that Article 226 and 32 of the Constitution are the basic structure of the Constitution, and power can never be, these power never be ousted and excluded. Why? Because these powers or these provisions are to be declared as basic structure of the Constitution. Now, one question may arise: how is Article 323B? Sorry, how is Article 31B compatible with above assertion of Supreme Court? It is not compatible. Means that one question is to be raised: how this Article 31B is going to match with the above assertion or above quotation given by the Supreme Courts. And another serious question: can an act which infringes basic structure of the Constitution be validated by including in ninth schedule? Because it was being happened earlier. Because 31B was in its retrospective in nature. So that's why another important and serious question was raised: can an act which infringes basic structure of Constitution be validated by including it in ninth schedule? So it amounts to validating an constitutional amendment. which infringes the basic structure of the constitution, something which the constituent power in India cannot achieve. And now certain aspects of these questions have been recently recognized, and a nine judge bench was constituted in Ayar Kohilo for determining the nature and character of protection provided under Article 31B of Constitution, made after 24th April 1973. So, as the judgment itself records, the fundamental question faced by the court is: first, whether on and after 24th April 1973, when basic structure doctrine was propounded, it is permissible for Parliament to immunize the legislation from fundamental rights by inserting it into the ninth schedule. And if so, what is the effect on the power of judicial review of courts? After elaborate discussion and considering the various jurisprudential concepts regarding constitutionalism and the principle of constitutionality, the court noted that Article 31B only provides restricted immunity, and it seemed that original intent was only to protect a limited number of laws. Limited number of laws, and only all those laws which were relating to the agrarian reforms. But the court also noted that from the 13 initial laws, initially 13 laws were added to the ninth schedule. 13 initial laws which were inserted in ninth schedule, the number had gone up. Now the number had gone up to more than 284 over the years, which showed that it is no longer a mere exception. So it was observed that in absence of guidelines, the absence of guidelines for exercise of such powers meant absence of constitutional control, which results in destruction of the constitutional supremacy at the cost of parliamentary hegemony as well as denial of full power of judicial review conferred by the Constitution under Article 32 and 226 to determine the constitutional validity of such exercise. Now, the Supreme Court clearly stated that Part 3rd is amenable. Now, the Supreme Court clearly admitted that part third is amenable but subject to basic structure. Means this judgment is an authoritative precedent for the proposition that Article 14, 15, 19, and 21 are the part of basic structure of the Constitution. In Ayar Kohilo, in substance, does not lay down any new principles as such, since the basic issue had already been decided in Vaman Rao in 1981. It may, however, be of some relevance as an overview of constitutional limitations on the powers of the parliament and state legislature. It also recognizes Minerva Meal on the question of balancing of part third and part fourth of the constitutional, and ultimately the court, while concluding, pointed out what the court had held, that they are first, a law that abrogates rights or violates law guaranteed by part third of the constitution may violate the basic structure, or it may not violate the basic structure if former is consequence of law. Means that in case if the violation of fundamental rights by the law, and if it is found that it is going to violate the basic structure, means that then if former is the consequence of law, whether by constitutional amendment of any article of part third or by insertion in ninth schedule, such law will have to be invalidated, will have to be declared invalid, will have to be invalidated in exercise of power of judicial review by the court, and the validity and invalidity would be tested on the principles of laid down in this judgment. Means that in case if the violation of fundamental rights are going to amount to destroy the basic structure, then that law can be declared an invalid law and unconstitutional law. So the majority judgment in Keshwanand Bharati case read with Indira Gandhi case requires the validity of each new constitutional amendment to be judged on its own merit, to be judged on its merit, the actual effect and impact, the actual, what is the test? The actual effect and impact of law on fundamental rights under part third of the constitution has to be taken into account for determining whether or not it destroys the basic structure. The impact test would determine the validity of the challenge. All constitutional amendments made on or after 24th April 1973 by which the ninth schedule is amended by inclusion of various laws therein shall have to be tested shall have to be tested on the touchstone on the touchstone of basic structure means ke on the touchstone or standard or criteria of basic structure of constitution as reflected to article 21 read with article 14 and 19 and the principle underlying them. So put it differently, even though the article is though the law or act is added in ninth schedule by constitutional amendment, its provision would be open to attack, or its provision would be open to attack or challenge on the ground that they damage the basic structure of the constitution if fundamental rights or fundamental rights taken away or abrogated pertain to the basic structure. Means that in case if the fundamental rights, the violation of fundamental rights pertains to the violation of basic structure, then it would be open to challenge. Means that although all those were acts or laws were added to the ninth schedule after on 24th April 1973 or after 24th April 1973, they are subject to challenge. They are open to challenge. In case if they had been remained a tool for violation of fundamental rights and that violation relates to the destruction or violation of basic structure, then all those would be open to challenge or open to attack. So the justification for conferring protection, not a blanket protection, on the laws included in ninth schedule by constitutional amendment shall be a matter of constitutional adjudication by examining the nature and extent of the infraction of a fundamental rights by the law or by the statute sought to be constitutionally protected and on the touchstone of basic structure as reflected article 21 read with article 14 and article 19 by application of right test and essence of rights. Right test and essence of right test taking the synoptic of articles in part 3rd as held in India, as held in Indira Gandhi case, applying the above test to be the applying the above test to the ninth schedule laws. If the infraction or attacks affects the basic structure, then laws will not get the protection of ninth schedule. Now, uh, coming back to little bit about Vaman Rao case related to especially uh, article or amended article 31C. As we discussed, this amended, this extended and amended version of article 31C was challenged in Minervaville case, and Supreme Court struck down the extended version of article 31C. And court held that primacy of all directive principles or laws related to all directive principles over fundamental rights under Article 14 and 19 violate the basic structure of the Constitution. Violate the basic structure of the Constitution and power of judicial review also, and destroyed which was declared at the basic structure of the Constitution in Indira Nehru Gandhi case. In Vaman Rao versus Union of India, the Supreme Court held that 31C, as it stood prior to the 42nd Amendment, 42nd Amendment made in 1976, was valid, as its constitutionality had been upheld in Keshwananda. But in one case, it is the Sanjeev Cock Manufacturing Company versus Bharat Cocking Coal Company Limited, and it was the case of 1983. Here, the Supreme Court dissented from the Minerva Mill opinion and opined that question of constitutional validity of Article 31C appears to us to be concluded by the decision in Keshwananda Bharati case. But this observation appears to be an obiter dicta and not conclusive on the question of validity of Article 31C, because in case 31C, because in Keshwananda Bharati, Article 31C was partly valid. Article 31C partly valid and partly